Hello, Ethan Vessels, lawyer in Marietta, Ohio. We're going to continue our discussion involving oil and gas topics. And the topic for this video is, why should you read your existing lease? Now this video, as with some of the other videos, have really been directed for people who have land, but there is an existing lease. It may be 5, 10, 20, even 100 years old. Now the whole issue that's going on in southeast Ohio with the Utica Shale is of course the ability to lease the land to one of the deep operators in order to get the Utica Shale out. Well, and this is usually accompanied with large bonuses and increased royalties. Now if you have an existing lease on your land, the lessee, the entity or the business that is producing the oil or gas from your property, has the gas rights. And they have the ability to assign or sell their gas rights to one of these deep producers from Texas or Colorado or wherever. That's why it is particularly important that you read your existing lease. We are finding issues that really affect the ability of what we call the shallow producer to transfer that lease to a deep producer. Here are some of the common issues we're seeing. One is an anti-assignment clause. Whoever was the original lessor, that's the landowner, the original landowner who signed the gas lease, would have negotiated a clause into the lease that prohibits the lessee, the entity that's producing the oil or gas, from assigning that contract to another business or entity. So it is a contract that only that business or entity, the lessee, can hold. They can't assign it further down the line. Now we have one of these cases right now, and it's being hotly contested because the lessees are taking the position that it's an unreasonable restraint on their ability to alienate their property rights. We're taking the position that the contract says what it says. So you need to know if that's in your contract. Second, pooling restrictions. Now I talked about this in another video. Pooling and its related topic of unitization has to do with the ability of the lessees, the producers, to aggregate property together into drilling units. Now the deeper the well, the more land you typically need. And on these Utica shale wells, with the horizontal drilling, they need 640 acres. So they need to have the ability to aggregate land together. And many of the leases in southeast Ohio had pooling restrictions. Sometimes it said you couldn't pool the lease with other land altogether, and sometimes there are limits on how much they can pool. Now this is not a reason why you can cancel your lease or have it voided, but it is an impediment to a deep producer using your land, so it's a negotiating chip. You need to know if that's in there. Defined production. Now, in another video we talked about the habendum clause, and a lease lasts typically as long as oil or gas is being produced in paying quantities. However, there are a very few types of leases where the original lessor, the landowner, specifically defined how much production was required. Some leases literally say, I must get $200 a month in royalties every single month, and if it stops, the lease ends. But you don't know if that's the case until you read your lease. And if that's the case, you might be able to get out of your lease even if there's production and otherwise paying quantities, but it is below that threshold. You need to know that. Depth restrictions. Some leases, even when they were originally signed, said that the oil and gas rights were conveyed to the lessee, the producer, only down to a certain level. So they may only have rights down to the Berea or the Clinton levels, and the deep rights, where the Utica Shale is, are reserved for the landowner. You need to know that. The other category we are seeing, and there's lots of these cases, is the indefinite promise to produce, or these nebulous delay rental arguments. And there's all types of variations of this, but the bottom line is many of these shallow producers are trying to come up with ways and tying it to the language of the original lease, making the landowner believe that their land is being held up, even though there's never been any production at all. Sometimes they have clauses involving the primary term, which we discussed in another video, that are indefinite, meaning there's never a promise to drill. They just say we've bound your land up for 10 or 20 years or forever. Another thing is producers will have a primary term, and then beyond that they don't produce anything, but then they pay payments that they're calling delay rentals. And we could fill an entire 2-hour video on what delay rentals are and what they're not. But courts in Ohio have stated clearly that delay rentals only apply during the primary term. Put differently, if they haven't been producing oil or gas and there's a primary term of, let's say, 1, 2, or 5 years, the producer can pay the landowner money just to hold the lease open. But that does not apply after that 1, 2, or 5-year term ends. So if you're getting checks in the mail and you don't know what they are, you need to figure out what those checks are. Are they royalties? Royalties are payments for the oil and gas that are actually taken out of the ground, and they are paid to you at a market rate. If you are just getting a check and it's not tied to any production, and particularly if the producer is trying to tell you that it's a delay rental, you need to figure out what that is. And as I said in a recent video, you need to make sure you know what you're doing. When it comes to signing documents, our mantra is think before you sign. And if you are encountering any of the problems that I've just talked about, you really need to talk to a lawyer. We sure hope you call us. We're doing a lot of this work throughout Southeast and East Ohio. Please visit our website at www.fieldsdehmlow.com, or you can call us 740-374-5346. Thank you.